We're going to start this workshop on the family justice process. This is one of 3 workshops that are dealing with the same broad topic with different panels. But I'm going to turn it over to Justice George Zutrin.
What we attempted to do this following up last year, several of us were involved in a program called The Role of the State in Family Law. And we tried to bring together an international group and a cross-profession group to discuss these issues. One of my goals personally was to see if we can talk about walking the walk, not just talking the talk, and that is that 50 years of UFCs, we have a mission, vision, and value statement, and sometimes I'm left with the impression, and forgive me for doing this, where we have so many professionals who are in the family law process, and we as family law professionals haven't learned how to get along. And often, having been a lawyer who did family law, now a judge doing family law, I often see us in the family law process blaming each other for all the ills of the world in family law. And you would have thought that AFCC would bring together the people who have common goals, common themes, regardless of what profession, and recognize all of our roles to play. I also noticed that this year, in the last 2 years, we have had more reviews and reports coming from UK, US, Canada, where everybody wants to reform family law. And usually everybody wants to do it from a satellite, looking down and giving advice about how we should do it and improve it. Most of the advice is relating to, well, we don't have any money. Is there a way to get rid of everybody and having them do ADR? And then, of course, if you have private ADR, you have to pay for it. So the idea is to build on this.
So I'm Nick Balla, Professor of Law in Canada. Beside me is Justice Diana Bryant, Chief Justice of the Family Court of Australia. The Family Court there is a specialist court. It deals with family law. It does not deal, for example, with child protection. Beside her is Professor Andy Shepard, a well-known American law professor who is also the editor-in-chief of the Family Court Review, the chief publication of the Association of Family and Conciliation Courts. He's written widely about family law, family justice reform. Beside him is Judge Jill Moss, who is a judge sitting on the New Zealand Family Court. One of the things we're going to be starting out with is looking back into the past, looking into the present. One overriding cloud over everything else is the changing atmosphere about public spending in all of our countries and countries of the size that are facing the debt deficit problem, how to deal with that, what that means for the family justice system, and that I think will be one of the themes that will come out.
Thinking about this, it seems to me that we need to put today's problems and tomorrow's solutions into some context. And I thought the context was really where we've come from in the last 50 years. So I've just doing a few slides for you, which I've called A Journey from 1963 to 2013, from Bowlby to Big Bird. Let's have a look at those figures. Interesting, aren't they? These are in US dollars, when gas was 29 cents a gallon. The cost of a new car was $3,233. And this is what was happening in 1963. Some of the early work of Bowlby on attachment, Solnit, Freud and Goldstein, really the only researchers at that time. Some of the feminist stuff that we got to know. No-fault divorce, just to remind you what it was like in 1963. So this is what's happened really in the last 50 years. And when you go through it, a mighty lot has happened. No-fault divorce, a much greater understanding of child development from Bowlby, Rutter, Goldstein, Freud and Solnit, to all of the research we have today. Mediation and ADR, collaborative law, a body of well-qualified social scientists, psychologists, psychiatrists who can provide expert evidence, better understanding of family violence and its effects, better understanding of the frequency and reporting of child abuse, an understanding of how neuroscience enables us to understand brain development in children, an understanding that court processes are generally harmful to parental relationships and thus to children, alienation issues and social problems arising from separation and divorce, blended families, growth in the numbers of self-represented litigants, increased increase in incidents of mental health and substance abuse issues for the courts, availability of good quality research, capacity to have prenuptial and postnuptial binding agreement, the Convention on the Rights of the Child, and in particular how the voice of the child should be heard, children's rights in a more general sense, the acknowledgement and need for a well-trained and knowledgeable judiciary, internationalisation of family law, including the Abduction Convention and other international conventions, the Hague Network judges and direct judicial communication, reduction in availability of children for adoption, corresponding use of technology, IVF, etc., and surrogacy issues, rights available to married couples becoming available to unmarried couples and same-sex couples, same-sex marriage and civil unions, LGBTI as parents and litigants and specific issues that affect them, administrative arrangements for child support, increase of women on the bench and in the legal profession, changes in social attitudes to women, to fathers and their role, social changes to work patterns of parents, understanding the importance of Indigenous cultures and minority cultures, a growth of litigants who know their rights and are more demanding of courts, those who don't speak English as a first language and require interpreter assistance, use of the internet, Facebook, Twitter, etc., and technology in the community and in courts, the initial availability of legal aid and legal service to litigants, and in more recent times the diminution in that service, the cost of legal services being beyond many middle-class people, the understanding of and the need for efficiency in case management, globalisation and the ability to travel, live and marry in other countries, and understanding that the family law system is significantly more than family court and extends to outside organisations, ADR and funding by governments of programs designed to assist separating parents using only the courts as a last resort, the need for the different disciplines to work together and have respect for each other, such as the AFCC provides, the challenge of teaching law to Gen X, learning from different countries, the possibility of a user pays versus courts providing a free system for those who can afford them.
Thank you. And I should say, as someone who teaches law, I teach in two areas. I teach contract law and family law. And in contract law, at least half the cases we do are wonderful old English and Canadian cases that were decided before 1963. In our family law book, there's almost not a single case that was decided before 2003. The family justice system, family law substantively and procedurally has changed dramatically, and whole new professions have been created in the last 50 years.
In New Zealand, we're lucky to have the unified court, and the unlucky bit is that the judges need the cognitive flexibility to do it all on any one day. Good for the individual families because, of course, you get one family, one judge approach to things rather than multiple short-stop boutique shopping, if you like, for issues. Does it matter that we have the same judge? Yes. Does it matter that we use the same psychologist repeatedly? Yes. Does it matter that we use the same counsellor? Yes. And so the more that we recognise that despite the breadth of change, despite the speed of change, despite the digital stuff, actually this is a focus on human beings communicating with one another at a time of high stress.
So a couple of reactions. In that 50 years, family laws will emerge as a specialty, and it needs to be recognized as a specialty. I'm not talking from a lawyer's perspective. That is not a recognition. And the other thing I want to say, Nick said we were from 4 jurisdictions. We're actually from 54 jurisdictions. We need all of you from Canada and New Zealand to understand that Utah is not Miami, that Miami is not New York, okay? We are not one federal family law, despite what everybody thinks, okay? Family law is a state responsibility, and it's going to be very difficult for me to generalize about the American family law system, but I'll try. The reason we have 50 different family law systems is the same reason we are able to stay together as a country. This is a very diverse society with very diverse states. Utah is quite different than New York. Their mores are different. The way they organize their family courts are different. And one of the ways we manage to stay together is, okay, Utah does its thing with families and New York does its thing with families within a broad framework of constitutional rights and legislation. I want to come back to the expertise idea. The legal system has not adopted to that idea. Okay? It's adopted in some of our places in the United States. Okay? And I will talk a little bit more about the family law bar later, which has adopted to that idea by basically abandoning lower middle class families. And there's a whole bunch of things that we sort of need to talk about. But the fundamental drive, you can't do what Jill does, okay, unless you have a specialist family law judge who is able to deal with the diverse families and all of those community resources and all of those psychologists and divide the property and all of the things that go with that. The judicial selection system in the United States has absolutely nothing to do with that. None. Okay? And until we adopt that system and create a way to train family lawyers for the system she's discussing, then we might be able to make a little bit more progress. We have moved, and it fits with the prenups and all of the other stuff. Basically, the idea is families should self-determine. They should, if at all possible, reach their own agreements for all kinds of reasons. Privacy, they're more likely to stick to it. They're more likely to, and that's how families generally make decisions. The legal system protects rights and adjudicates. Okay, and it has to do that appropriately. And so, but what we've done is we've kind of blended the two together, right? We basically get the idea that self-determination is within the context of the court system. Most states in the United States have a system for mediation of what we call parenting disputes, child custody disputes, okay? Increasingly in child protection cases, there is mediation. It's the idea that the culture, the family, can express its own values in dealing with it. And there's a whole market of private mediators who've developed that. In New York, at least, which is the adversarial capital of the world, in Manhattan, particularly because you're dealing with very wealthy people who are very competitive and like to win, there's virtually no mediation occurring for rich people. Okay? There's no court-mandated mediation. In California, which was the first state to mandate court mediation, okay, for parenting disputes, the cutbacks in the public sector have been so severe that to call it mediation, what's left, demeans the word. Okay, I mean, they're rushed, and it's just incredibly difficult. Okay, what do we know about mediation? If it is done in a way that gives parents the chance to speak their minds and have voice, and give them time and attention, they think the process is just the cat's meow. They think it's just great. Okay? If it is done in a rushed, crappy way with unqualified people, it's bad. It gives them the bad idea of what the process is all about. So if I had to invest money in something, I'd invest money in mediation and getting better mediators and getting more training. Okay. Now we need to talk for 1 minute about the legal profession. They still haven't fully adjusted to mediation. As I said, the rich people, the ones who represent the rich lawyers of the world, the rich lawyers who represent the rich people of the world generally don't endorse it, generally don't do it, with exceptions. Okay, so this is perceived of, in part, as a process of second-class justice for lower middle class and poor people who cannot afford the legal system, which is a very serious problem. Our community has done a relatively poor job in conveying to the public how important mediation is to their children. It's a public health issue. It's not a court process issue. Children have better outcomes when they have when their parents mediate. Okay, and there's all kinds of, I know there's a whole bunch of advanced institutes, and I appreciate all of them. It's been great. But what we have not done is convey to parents how important it is that they choose it, and that if courts order it and it's in their best interests, and in lawyers who subvert mediation, frankly, are acting unethically for the benefit of their children. Yeah,
well, if I can go back even further, we've actually got quite a good history of mediation. When the court was set up, the Specialist Family Court in 1975, they put family consultants within, who are psychologists, social workers, within the court system, and I think we were probably the first court in the world to have that system. And it's worked very well for us. And so their job originally was to mediate, as well as being expert reporters, custody evaluators. Over the years, we lost some funding, and also I think the community in Australia started to get a lot of expertise in mediation. And fortunately, the government has always, to some degree, funded non-government organisations to do mediation work. So there's been a lot of building up of mediation expertise outside the court.
One of the things that makes family law unique, and to me is one of the reasons for having both specialized courts and specialized judges is that the law in general is retrospective, and the criminal justice system would be a classic example of that. What happened last year? Who shot whom? Was it self-defense? It's all looking into the past. And that's true of much of civil law as well. Family law is really very prospective, and the most contentious parts are often about what will happen in the future, what will happen with the children, what will happen with support, what will happen with the house. And it's really helping families to restructure their relationships into two separate families, for example. And it's also about giving people the skills and attitudes and structures so they can make their own decisions in the future. So hopefully there's a process that may take months or years to resolve, but after that they're going to resolve things on their own. They're going to have to make their own decisions about the children in the future, let alone when the children are adults and they have grandchildren and so on. Justice Sutton does a lot of things, but he's not going to decide who's invited to the wedding of the children. And we see, and it was pointed out by Judge Moss, that the role of the judge has changed. And certainly in Ontario, one of the things that we have to some extent subsidized mediation provided by the government in many places. But if a couple is separating and they can't agree, going to a judge is actually often very useful because we have conferencing, and the judge may actually be a free mediator, different kind of mediator than a mediator in private practice, but often having a mediative role. And much of and of course, most cases are resolved, sometimes in Canada, a significant portion are resolved by judges through a quasi-mediation process. And so one of the things we hear about is overlapping roles, not just lawyers and judges, mediators who may not be legally trained, the role of an assessor often, and we're going to talk about assessors in a moment, often in fact is mediation. We think, oh, you're going to go off and get an opinion from a social worker who's investigated the family, but in fact the report comes out and it's the basis of a settlement, so different kind of dispute solvers.
The most useful collaborations are those in the non-adversarial system. Psychologists working with lawyers, creating mediation teams, or working in collaborative law seems to provide good services to families. The mental health people seem to like those roles because they don't have to take sides and they don't have to testify. Usually there's some privilege or evidentiary privilege or some confidentiality around it. They work for the benefit of the children. So collaborative law in the United States has an elaborate structure where they bring in mental health consultants. In some places, the mediators on the parenting issues are non-lawyers. Some places they're lawyers. Some places they mix together. They can provide great insight into how to develop parenting plans, and the lawyers draft agreements very well, get people focused on issues. It's a very useful teamwork. On the adversarial side, I need to go back to 1963 because and I'm only talking about rich people. No experts, basically. Mental health experts in custody cases, approximately. 1970, you start getting the mom gets one, dad gets one. Okay? They each hire their own. They don't talk to each other. They don't work together. They don't talk to each other. Essentially, they're hired guns and their testimony is worthless because they don't get to interview the kids and they don't get to interview either side. Good idea comes in, and this is an idea drawn from other aspects of civil procedure. Let's get a neutral, okay? And that person will work for the court. There'll be no confidentiality. The parents will pay for them in most places. Okay, good idea. And ergo, the forensic expert is born, okay? And a lot of dispute develops about how good those forensic reports are. Okay? A new industry is born, consulting experts for mother and father, okay, who are then hired by mother's expert and father to critique the report. Then is born yet one more expert, since the consulting expert can't testify because they're tainted now. So we each get a testifying expert. So we've gone from 0 to 2 to 1 to 5. Children are not being served by that. Okay, it may be that the fact-finding process becomes more high quality. It may be that reports get better, but I'm not convinced that there's any better fact-finding on because of the inherent uncertainty in making predictions about the future, and risk assessment, which is what a custody evaluation is. The best use of custody evaluations, the research that I've seen shows, is a settlement tool. The good side of the consultants and the good side of it is they help people settle cases. They provide them a plan. One of the things that we've learned in mediation is not everybody can just facilitate mediation. There are some people who need structure and order and some authoritative decision. The custody evaluation helps. The mixed roles point is absolutely central. Many custody evaluators believe they are not mediators and they're just supposed to present their report. Okay? And they don't work with the family to develop a plan. Okay? Because there's a conflict of interest there and then they're going to be called to testify. And the mix, now obviously every time you separate roles, you make things more expensive. Somebody else has to get to know the family, somebody else has to be paid, and that's one of the main crises, in my view, in the family law system. So we have a crisis of funding, okay? We have a crisis of people being forced into a system without necessary expertise. We also have a huge increase in caseload. Essentially, in my view, the family courts and the family justice system are being held together by Band-Aids. It's because they don't have lawyers, the funding's been reduced, they present problems to the judges, if one party's self-rep and the other one's not, that's a major problem. Two self-reps, okay, so that's enough. What has happened in response to the self-rep problem in some courts that are good ones is a whole group of the idea that the court has a responsibility for providing information and facilitation to the self-rep population. That is a really good function. The research indicates that people really like that. However, okay, there are enormous restrictions around what they can do. They can only give legal information and not legal advice. When you ask the self-reps what they want, they need legal information/advice together, and they...
So in New Zealand we have the current reform. Our reform proposes to bar lawyers in what I call now in my head, as I think about this, the clinically normal case. The clinically normal case has these symptoms. It has a realignment of family relationships. It has children. It has profound emotional distress. And it has otherwise functioning adults and children. It does not have profound symptoms which are clinically diagnosable. Just like we no longer go to the doctor for antibiotics when we have a cold, we like Get Better. They will no longer have the full Monty in the clinically normal divorce. I want to suggest that that might be no bad thing. No matter how good a court system is, how good a judicial system is, if we're doing it right, we're in quick and out quick, and we're leaving people with their characterological soups to work things out in their own families for their own purposes. So why would we give them a full Monty, again, the clinically normal case, why would we give them the full Monty to disguise their own characterological soup? Much better give them a well-qualified, well-focused judge who will quickly diagnose the issue, point out information sources, emphasize the skills they've already brought to their families. The fact that they're already so competent means that once they get through this period of enormous turmoil, they'll be competent again. That there will be compulsory parent education. The compulsory parent education will look, focusing parents on how it feels to be our children, on how these are lifetime relationships. The only choice parents have is whether the compulsory relationship is a good one or a bad one. They don't have a choice not to have a relationship. So this curriculum will assist people to get on that track of believing that this is a point in emotional distress and there are ways of living in good relationships. So that's the conditioning before they get to the court. They then go through our family dispute resolution, which is mandatory mediation, and only then, if they can't sort an issue, is it referred to me. And when they see me, I do the same old, you're going to be parents forever, now let's sort this one out fast. And I will leave you with your characterological soup.
The other thing that everyone also needs to understand is a lot of our jurisprudence on family issues comes out of the juvenile delinquency cases. In re Galt is our famous case. Okay. In re Galt was essentially a declaration by our Supreme Court that kids who were accused of crime, they got a truncated proceeding. It was supposed to be good for them. The wise judge was telling them how to be better in the community. And okay, so they got no lawyer, no transcript, no statement of charges, nothing. And the Supreme Court said, well, and they also got no rehabilitation. So it was a disaster. Our Supreme Court said, well, at least give them due process. At least give them a lawyer, a transcript, notice of charges, and all of that stuff if you're not going to give them rehabilitation in one way or the other. And they didn't buy the idea that there was a really wise judge sitting there who would do good things for this kid in the community. We've had bad experiences with these sort of informal, and I'm one of the world's U.S.'s most significant ADR advocates, but we've had bad experiences with informal justice in the family area. We have very, very active interest groups that insist, which we haven't even talked about, that insist on due process protections. Women's groups and men's groups. So I wish we could do New Zealand. I mean, I think we need some of your stuff, but it's not us.
I want to turn to something that Andy mentioned and start perhaps with Judge Moss, and that is on the advocacy groups.
My experience of them is that as activist groups, they will precipitate conflict. They will push the thinking, emotionally distressed person into the most extreme position. I think if we had a due process lobby group, they too have their place. This is about finding a balance. But fundamentally, I keep coming back to the whole business that it is about continuing human relationships. And if we give preeminence to any one particular group, one particular service, one particular philosophy, we run the risk of excluding the long-running issue, which is the quality of the human relationships that come out this sausage machine end that is the family court.
I think unbundling is the hope of the legal profession for being relevant to the people who don't have the lower middle class and people who don't have lawyers now. What amazes me is it's not heavily advertised and not heavily available. SRLs, I think, are having problems connecting with unbundled. That's the hope of the legal profession, expanding it to that collaborative law is essentially a form of unbundling. Okay, it is just settlement representation, essentially.